Morning. Please be seated. We are here for oral argument in Limad versus Mira Vista Holdings. Our cause number is CV120619. These proceedings are being audio and video recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. You'll be responsible for reserving time for rebuttal if you so choose. We have read the briefs, we've conferenced this matter, and we're looking forward to your argument. And with that, counsel, you may proceed.
Thank you, Your Honor. Dennis Wolenchek, Your Honor, and Tyler Swenson here for Appellant Limad. Your Honor, Your Honors, we are brought here because of a ruling on a motion to dismiss that we believe was obviously an error and a refusal to allow us to even amend or argue the matter. First of all, judges, to put this in context, what we're talking about, and I'll try to keep this as basic as I can for good reason. Mr. Wild was charged with the city as its designated developer of what is now the Tempe Marketplace. Toward that end, there was a bunch of properties that were landfills and contaminated properties on the site. His task was to assemble all those properties and to purchase them. And essentially, in doing so here, as it relates to this case, he did so through what I'll call half-truths, misrepresentative statements that were not only half-truths, but distortions of the truth. And those equal whole lies, and they're actionable. And we stated those claims sufficiently and attached the relevant exhibits for the court to determine those facts. And if there was any question about it, we should have been given the opportunity to amend, to make that clear. But here are the representations that they claim are matters of law, although I believe that if the court reviews the Rhodes v. Harvey case, as I just did while waiting here again, it clearly states that this is a distinction without a difference. At 270, the elements of fraud, the court said, contain no explicit requirement that a representation be one of fact rather than law, a legal opinion. And that is the trend of the law. What was represented were statements of fact, some of which were true as far as they went, but were misleading and misrepresentative as far as they were relied upon because of the other half of the story that was not told. Let me give you an example, 3 examples that I think are the most salient. The first one is that he stated the property is not covered by the insurance that he submitted the policy to Limad's agent, Mr. Robinson. The property is not covered, meaning Limad's property is not covered. That is true as far as it goes because anyone can see, and that's the problem here, that the policy that he submitted did not contain the Limad property on it. What he didn't say, and never said up and through the time of the sale, which Limad continued to labor under these illusions and never was told otherwise and never corrected, was that he was required by the redevelopment agreement, which was Exhibit A, which basically says that Mr. Wild, through his companies, has to get coverage. That's paragraphs 3.3 and 3.8 of Exhibit A, and that the city essentially is paying for it by obtaining federal funds which will be paid out of sales taxes in the future, which Wild only guaranteed, but was to come out of the sales taxes of the property that was developed ultimately.
What about the argument, though, that the redevelopment agreement was a public document on file available for your client's review, and that places this in a very different position from making factual misrepresentations that a party has no ability to discover?
Well, yes, Your Honor. I think the simple answer to that question, direct answer to that question is the situation that the court described, for example, in cases like Barnes versus Lopez, which is a case involving a zoning condition of a property. And there, as in other cases, which are consistent with that, I can just cite off the top of my head the S Development versus Pima case, Hill versus Jones. I mean, there are lots of Arizona cases that basically say the same thing, in essence, which is that when an affirmative representation is made, an affirmative representation, which I think is distinguishable from the Jones versus Chiato case that they cite, but where an affirmative representation is made such as this, There is no duty to investigate by the party that hears
What's
it.
the affirmative misrepresentation as to this other issue? I mean, there are arguably affirmative representations about the AIG policy, but where is the affirmative misrepresentation on this other issue?
Well, for example, the second one I was going to go to, Your Honor, is Urban continues to be liable to remediate or risk them being relisted as a Superfund site. Again, true but misleading. The third statement, no state, local, or
Why is that misleading, though? If
Well,
he
the
doesn't sell
reason
the
that-
property, isn't he in fact responsible for remediation?
No, as a matter of fact, if you look at Exhibit C to the complaint, which was the federal HUD document, it clearly indicates in there that, in fact, that's not the case. I think it's on page 1 and page 4, in which it's recited when they applied in 2004, that wasn't going to be the case. In fact, it says right in there that not only are all property owners to be covered, but it goes further to say that is one of the strong inducements for the property owners to even cooperate with this plan. So no, that wasn't true.
But does that say that the insurance will be provided for free to the property owners? Doesn't it just say you need to have insurance coverage?
Well, the other documents, I believe, cover that, Your Honor, in which case the developer under the redevelopment agreement, and I'll come back to the question that was asked me earlier, but the developer is required to obtain the insurance, but the city ultimately pays for it because they were going to get this HUD money and earmark money for the premium.
Well, it says there's a loan, but it didn't see anything that says the city is actually going to pay for the remediation.
It says up to, I
for
think, $6 or $7 million. Don't hold me to the number, but I think it's $6 million. And then the other $1 million for the anticipated cost of remediation, I believe, was specifically stated to be covered by the insurance policy, which the $1 million was going to pay for the premium, and that was going to be paid by the Section 108 funds. That's right in the document.
Before you move on, the part that you're saying is the affirmative misrepresentation is followed by this statement. You may certainly confirm this understanding with Amanda Stone at ADEQ. Doesn't that undercut the notion that this was some affirmative statement that your client was intended to rely on?
Which statement are you referring to, the no state or federal money?
No, I asked you what the affirmative misrepresentation was, and you said, Mr. Urban continues to be liable to remediate his properties or risk them being relisted as Superfund by the EPA. That's the part you read to me. But then the next sentence is, you may certainly confirm this understanding with Amanda Stone at ADEQ. Doesn't that undercut the notion that this was a factual misstatement that your client was intended to rely on?
No. First of all, Your Honor, I didn't finish my answer, and that's why I said I need to come back to it. I apologize to you because that's an incomplete answer on my part.
Double teamed.
Well, it's okay. But what I was going to say is the third one, and I'll come back to that, I promise, that no state, local, or federal money was earmarked at this time for remediation of the landfill, which, as I'm saying, under the documents under Section 3.3 and 3.8, it's clear in Exhibit C as well that there were funds earmarked, in fact, to pay for this. Now, to come back to your question, so that is an affirmative misrepresentation. Come back to your question, Your Honor. I believe that actually, and I don't mean this facetiously, was even more misleading and misrepresented to state that, because what it was really saying was, here's a statement that he knew was really false, but he's saying, well, you can confirm this with ADEQ. First of all, I don't think he intended for them to do that, and even if they did that, I'm not sure what ADEQ would have known about that issue any more than he did. So there's no indication in the record, of course, because it's a motion to dismiss, that ADEQ actually had any more information on that than anyone else. We do know from the allegations that Mr. Urban of Lamar did not pursue that, nor did Mr. Robinson. And as I'm saying, under the case law such as Barnes v. Lopez, I don't think there's any duty to do that. Now, even if they had done it, I'm saying, to answer your question honestly, I don't think they would have found out anything on that issue. But as I say, that's not a false statement, that one, as it goes. I want to be clear on that. That's second statement, which is that he continues to be liable to remediate insofar as it's stated that ADEQ expects the property to be remediated. I have no problem with that concept, so that's all he would have found out. The real issue is what is left out of that statement. What's left out of that statement, as I say, it's purposefully misleading, because what's left out is that under Exhibit C, the HUD letter you'll see on page 1 and 4, under paragraphs 3.3 and 3.8, that is the fact that the only thing that's relevant to Lamad is who's going to pay for it. And the key is that it's clear that what he wasn't saying is, and clearly leaving the misimpression by saying there's no money earmarked from the government for it, clearly leaving the impression that Mr. Urban of Lamad would wind up paying for this, which is exactly why, to get to the conclusion, exactly why When the sale transaction actually occurred, Mr. Urban reduced the price substantially, over $1.3 million, whatever, because it was represented that Mr. Wild would have to incur the cost, you see, of that cleanup. It's really kind of simple. You know, if you're selling your house and there's things wrong with it, the buyer's going to say, well, I got to do this, I got to do that, here's an estimate, and you reduce the price or you do it yourself. And that's the basic import of what he's saying, is that, look, Chuck, you're going to be left with this problem if you don't sell it to me, and I'm amassing all these properties, so I'm the only logical buyer. And as a result of which, I got to clean all this stuff up, and there's no money to do it, there's no policy to do it, there's nothing to do it. I'm stuck, and you got to reduce your price. And that's what happened on a continuum through the final sale transaction.
Why does where the money come from matter as much if he understands that there is a problem with the property, he understands that somebody has to pay for it. If the example you offered in your reply brief that I'm selling a home and the buyer says my bank will
Right.
only loan me $150,000, but in fact there's another bank that will loan him $200,000. Why is that significant to the seller? Why does it matter where the money comes from? Isn't it just a determination? The seller has to just decide how much he's willing to accept.
Well, to some extent,
that
yes,
logic.
yes, to some extent, that's correct. What is relevant to a seller is whether he's going to wind up having to pay for this. That's fair. And that's, again, part of the misleading nature of this. The difference is, and the only addition to it that I can tell you, Your Honor, is that where the buyer is saying, look, this is something I've got to do, and I don't have the money to pay for it, basically, I've got to, scrape up the money to pay for it, the seller is further induced into saying, well, okay, if you got to do it and you got to pay for it, if he had known that somebody else, i.e. the city, whose interest it was to develop this landfill into a marketplace and get sales tax revenue, if he'd known and understood that Mr. Wild was not going to be responsible, was the actual purchaser, he would have said, well, listen, you can't deduct the price if the city is going to pay for it, not you. And that's the only reason we bring that up.
And I apologize if it's clear from the record, but specifically the references to the record that show that the city is actually going to pay as opposed to just obtaining a loan, because the redevelopment agreement says the developer is responsible for the remediation cost, is my understanding.
No, that's part of it, but then it goes further on.
And so what specific references are you saying show that that there is going to be a pot of money that will be used for remediation?
Well, I think specifically to answer your question, if you look at 3.8 of Exhibit A, which we attached to the complaint, it says right in there that the AIG, which is the insurance company that we're talking about, after stating earlier in the agreement that what they refer to as the ICR, which is the remedial cost, will be done by the developer, it then provides in 3.8 that essentially that will be paid by the AIG company, which is the insurance company. The city is going to be responsible to pay essentially the
Where
premium.
does it say that the city is responsible for paying the AIG for the AIG policy?
Well, I think the answer is real quickly. Yeah, what page is it? Yeah, if you go to the second page of Exhibit C, which is the federal government memo that Mr. Urban later found in 2010, this explains how the whole process works. I think that's the best answer I can give you, Judge. And I think if you go to page 4, of Exhibit C. Anyway, Exhibit C explains it, Your Honor, the whole plan, and that the city is to pay. It says, for example, on the first page real quickly, the $7 million in Section 108 funds will be used for the environmental remediation costs, estimated at $6 million, and to fund the premium on the environmental insurance being provided. So that's the city obtaining that. Then it's made clear that the estimate is only $6 million, and that these funds will be granted directly to AIG. So the scheme, essentially, of how it was to work is explained not only in 3.3 and 3.8, I think, but also in the document that Chuck later found in 2010, which explains that, in fact, it is the city that's going to be obtaining this loan and paying for the premium, et cetera. So that's exactly what led to the filing of the complaint, because it was that document that we later found, or Chuck later found, in the course of discovery in a different matter, that he requested that he didn't receive and got through a FOIA request that explains that, in fact, it was the city that paid for this premium. And I think if you look at the other documents I've referred to, which would be the Exhibit A, and then 3.8, which describes this process of the city will submit and diligently pursue the application for the $7 million in loan funds in 3.8, and upon granting of that loan, the loan proceeds shall be deposited with AIG. I think it's pretty clear, without any question, and we alleged it was clear, that the money was coming from the city and not from Mr. Wild. So essentially, what he was saying to us in conclusion is, you know, I have to pay for this. There's no money earmarked for it, which was false. Even at that time, it was false. It was certainly false at the time of the sale. But I've got to take care of this. So, Chuck, you've got to discount your property to help me do this, because even if you're left with it, you've got to do it anyway. And so Chuck said, okay, fine. Then I'll discount the property to you. In fact, if you look again at the federal document, it makes it clear, as I say, I think on page 4, if I'm not mistaken, that it refers to the fact that when the city applied for this grant, that all property owners were to, in fact, be covered as well, and that, as I said earlier, was one of the inducements that they claim that they felt should have been
And it suggests that all property owners would be covered without paying any type of premium. Is that what you're suggesting?
Oh, yes, absolutely, yeah. There's no statement that the property owner is going to be paying any premium. Again, that's what I just went through. The city was paying the premium, and that's clear in the redevelopment agreement. So essentially, if you take all of these three statements, these are statements of fact. We allege they were statements of fact, and even if they were statements of law in some way, they were clearly statements of fact that involved questions of law. I believe that the case law is clear that under Rhodes v. Harvey, under the Hildebrand case that we cited. And so quickly, with the time I have left, because I would like to retain a minute or two, let me just say this. There's a couple of quick things the court ruled on, as I say. One is a legal opinion. Two, the consumer fraud applies only to sellers. I find nothing in the statute, no case law that supports that position. In fact, there are fraud cases, I believe, in general, such as Lombardo versus Albu, that say that it's a two-way street. It's not a one-way street fraud. You can be committed by a purchaser or a seller. So I don't know what distinction the court made there as a matter of law on a motion to dismiss. And then the only other thing that he said, as I said, is that it was not involving a commercial transaction, which clearly it is involving a commercial transaction. I don't even know what to say to that. I think he was talking about the delay between the 05 statements that we deemed to be misleading and alleged to be misleading and misrepresentative and fraudulent, and the 2007 transaction closing. But the point is that there's nothing in the record to show that our client was disabused of any of those notions, that he felt that Wild would be picking up the tab for the remediation. And so I don't think the passage of time, as I said, in the Hildebrand case was a legal opinion, in fact, and there was a 3-year gap, and the court said that's interpreting Arizona law, and it said that so what? I mean, basically. So in conclusion, taking the complaint, Your Honor, on its face, on a motion to dismiss, assuming the truth of all the allegations contained therein, looking at the facts that were stated, and then alleging that those facts turned out to be misleading, misrepresented by virtue of discovery of the federal documents, which showed what really was the situation, as opposed to this business that there was no money earmarked and that he was going to be responsible, and knowing that he would have to obtain the insurance policy under his redevelopment agreement, and obviously not having any duty to go out and affirmatively investigate, and clearly alleging he did not know and investigate. On a motion to dismiss, this case should be remanded. And as I said, we weren't given the opportunity to even amend to clarify any of these points any further, so, or any oral argument on the motion itself.
Counsel, at any point did you present the court with an actual proposed second amended complaint?
No, we filed, no, Your Honor. We filed a motion for a new trial on these issues, and obviously we would have had the court allowed us, but we did not submit an actual amended complaint. I'm not sure that I've read anything that requires us to do that, but thank you. I'll reserve, I guess, a minute or less.
May it please the court, Michael S. Rubin and Laura Curry on behalf of the defendants' appellees. We submit that the trial court correctly ruled that plaintiff's complaint did not state a claim. In its motion pleadings, in its briefs before this court, and even today, you've heard great embellishments of what the complaint alleged. We believe in many respects the arguments that have been put forth mischaracterize those allegations. Obviously, this court's focus for purposes of reviewing the order dismissing the complaint must be on the four corners of the complaint. And the only question we submit before this court is whether that complaint alleged facts with particularity which would support claims for fraud, negligent misrepresentation, or consumer fraud.
Counsel, let's assume that that complaint does not state with particularity. Then why not give the appellants the opportunity to amend? I mean, isn't that like a threshold question that we should be visiting here? I mean, did they have that opportunity? Or, I mean, why shouldn't the trial court allow that to happen so that we don't get in a position on appeal where we're struggling mightily with arguably factual disputes?
Your Honor, the answer, I think, is right in the rules. Rule 15A2 specifically requires that if you seek leave to amend, you present the court with the proposed amended pleading and highlight the changes between the original pleading and the amended pleading. They never did that. In fact, they never requested leave to amend until they filed their motion for new trial.
And
so we think they...
Therefore, it was waived.
I think it was waived. They clearly had the opportunity.
Case law that says that. Is there a case law that says it's waived by failing to bring it before a motion for new trial?
Your Honor, I think you have to follow the rules. And if the complaint is being attacked as being insufficient, we clearly raised below that fraud was not alleged with particularity. We articulated the specific objections we had. They clearly had the opportunity, and I think just as a matter of law, it is waived. Secondly, Your Honor, they still have not articulated any theory upon which this complaint could survive. So there's the procedural aspect, but I also submit that there's this substantive aspect.
And just to make sure I'm following you, Mr. Rubin, you think it's waived, but if it's not waived, then they didn't comply with Rule 15A2, which would allow the court to ascertain whether the proposed amendments were essentially futile? Is that
correct? Correct. In fact, we believe that the plaintiff's claims are fundamentally and logically flawed. Whether other parties, including the city or the ultimate purchaser of the property, were required to or purchased insurance coverage, the plaintiff had no right, expectation, or reasonable belief that it could sell its admittedly contaminated property as if it was clean. And that's what this case boils down to. Notwithstanding plaintiff's rhetoric and misdirection, the only allegations in the entire complaint of an affirmative representation are contained in paragraph 20, which references the memo that I put on the board, and hopefully the court has copies because I'm not sure how legible that is. The complaint states no facts, and I heard counsel concede that essentially everything in that memorandum was correct at the time it was made. In addition, most, if not all, of the statements were Mr. Wild's opinions, conclusions, and his view of what the legal requirements were at that time. and that's all that memorandum says.
Is the statement true at the time that there's no federal, state, or local money earmarked at this time?
They have not made any factual allegation that that wasn't correct, Your Honor. And in fact, the only suggestion they've made is that there was this elaborate mechanism through various agreements, including the redevelopment agreement and the Section 108 loan, where the cost of remediation would be partially insured by AIG. So I will go to a question I was going to save, but I think it's appropriate to answer it now. If there is a duty to disclose, as counsel suggests, how far does it go? Mr. Urban and his lawyer, he was represented by his lawyer who was sent this memorandum, clearly knew that Mr. Wild's status was a representative capacity for the redeveloper under contract with the city under a recorded public document called the redevelopment agreement. Contrary to what counsel is now trying to assert, there was no suggestion in the complaint that they didn't have access to the redevelopment agreement and they didn't review the redevelopment agreement. It was a recorded document, which you can see on the face of Exhibit A to the complaint.
Aren't they saying the redevelopment agreement specifies that Mira Vista will be responsible for remediation, and they're saying the HUD document contradicts that?
Well, the HUD document does not contradict that, Your Honor, and there's no allegation in the complaint that that document was ever seen by Mr. Wild. It is an internal HUD document, and it clearly doesn't change in any way, and it couldn't, as a matter of law, the obligations between the redeveloper and the city of Tempe. It is a red herring, pure and simple. The obligations to remediate the property are set forth in a recorded document, which Mr. Robinson, who is Mr. Urban's lawyer, clearly had access to. And I would note, as I'm sure the court has observed, that the memorandum, this one-page memorandum, is dated December 6, 2005. Paragraph 21 of the complaint, which follows the reference to this memorandum, says that in May 2007, the parties entered into an agreement. 17 months went by between this one-page memorandum, which counsel concedes is essentially correct, and apparently they did nothing to check with ADEQ or do any further investigation, and if you believe what they're asserting today, notwithstanding the fact that it's not alleged in the complaint, they didn't even bother to look at the recorded redevelopment agreement. But the redevelopment agreement is a fairly lengthy, complex document. If counsel is suggesting that the buyer had an obligation to disclose what his legal obligations were under that agreement, I ask again, how far does that obligation go? Could, and I submit the answer is clearly yes, could that obligation, if it exists, be satisfied by handing Mr. Urban or his lawyer the redevelopment agreement and saying, I'm not a lawyer, I'm not going to explain it to you, read it. I think the fact that it's a known, recorded, public record suffices for that purpose. There was never any suggestion in the complaint that Mr. Wild discouraged in any way any investigation during that 17-month period on the part of the seller.
What about Mr. Wolinchek's argument? Because I think you raise a valid point, but when I asked him that question, he said Bradley and some of the other cases would still impose a duty on your client, notwithstanding the availability of the redevelopment agreement as a public document.
Well, I don't think that's what those cases stand for, Your Honor, and I would welcome the court's review of those cases.
Counsel, what about the zoning case where, the zoning case where they found that there was a duty for the seller to or the broker, I suppose. I don't know the exact details, but in essence, the zoning was misrepresented.
Yeah, I think,
It's a simple phone call. And pick up the phone and call the zoning office at the local authority and ask what the zoning is. They didn't do that, and yet the court still found a duty.
well, I think Barnes versus Lopez is a fairly unique case where it said that in that case, the seller, not the buyer, misrepresented something very specific that was known to the seller. I agree with Your Honor that it was certainly verifiable by the buyer, but what the court said was it states a claim that the seller was aware, specifically misrepresented a fact concerning the property, and I think that's important. It's a fact concerning the property, and the court merely said that in that circumstance, the buyer could rely on that affirmative representation and not make any further investigation. What we have here is, I'm sorry.
How about if Mr. Wild had said there's a problem with zoning on this property, it can't be used for anything other than something that's not going to generate a lot of money. Would that, under Barnes, would that then be actionable? Would that be fraudulent if the prospective buyer misrepresented what the current zoning status was for the property? Let's say the zoning had been changed to say that it's now for a commercial development, and the prospective buyer says the zoning hasn't changed, it remains, can only be used for agricultural purposes.
I think not, Your Honor, because I think the seller, the owner of the property, is charged with knowledge concerning the legal aspects of their own property. But I think it's possible in that hypothetical if the buyer made the specific representation that the seller could rely on it. But I think there is no current authority that would so hold. As I think several members of the court pointed out, if there was a duty to disclose this complex mechanism for funding the remediation of the property and how insurance played into it, that would not give rise to any right or expectancy on the part of the seller to benefit from that arrangement. So we submit it's not even material. If, for example, you have a prospective buyer of a residence who succeeds in reducing the purchase price by $10,000 because his inspector advises the seller that the roof should be replaced, and the seller says, okay, I'll agree to reduce the purchase price by $10,000. Would the seller have the right a year later to come back and say, you defrauded me because you didn't replace the roof, you never intended to replace the roof, you simply used that as a vehicle to reduce the purchase price? I think the question answers itself. No, that's not fraudulent. What occurred here did not conceivably affect the value of the property. Not conceivably. And the seller doesn't get a free ride, as I said earlier, for remediation of contaminated property. And that is what the seller is intending to do in this case. I think it's also extremely significant, Your Honor, Your Honors, if you look at this memorandum, that first of all, it's brief. It attaches the existing insurance policy, and this is done 17 months before the transaction even occurs. And to make matters even more clear, Mr. Wild, in several places, encourages further discussion, further investigation. He says, please contact Amanda
There'd
Stone.
just be an argument, though, that you would present to a jury to explain why this wasn't reasonable to rely on it, the length of time. If it had been 2 months before, then would that not make it more relevant if it's just a matter of degree, why would we knock it out on 12B6 grounds simply based on the...
I don't think the time by itself knocks it out, Your Honor, but fraud and all species of fraud must be stated with particularity. So I think it's incumbent upon the plaintiff to make allegations, factual allegations, that would establish reliance and reasonable reliance. I think as a matter of law, reviewing this simple one-page document, which counsel seems to concede is accurate as far as it goes, there is no allegation of fraud, and certainly not with particularity. I'll briefly address the consumer fraud issue. First of all, we believe that under the language of the Consumer Fraud Act, Lamad, the plaintiff in this action, cannot reasonably be construed as a consumer. The purpose of the act is to protect consumers in merchant consumer transactions. Mr. Wild did not sell anything. He did not advertise anything for sale. And I don't think it was ever contemplated that the act would cover either the parties in this transaction or an alleged representation or omission that doesn't even go to the value of the property. And I think that's extremely significant. In short, we believe that the trial court got it right. The complaint in this case failed to state a claim. It failed to plead fraud with particularity, and the court should affirm and award appellees fees and costs. Thank you.
I'm going to run through this quickly for obvious reasons. First of all, the duty is assumed under the Founders versus Murray case once you choose to speak. That case is clear on point that negligent misrepresentation occurs even if you have no duty once you choose to speak. And then if you choose to speak, the point of this whole case is you have to choose to speak accurately, fully, not just half of the truth, not just part of it, but all of it. Section 542 and Section 545 of the Restatement of Torts, second, I would ask the court to look at in terms of legal opinions. I think it says it all, and I don't have the time to go into it, but I refer the court to that. Reasonable reliance, question of fact. No, we didn't concede that this document is truthful. It's not truthful at all in light of the real facts that we later discovered. And finally, as far as consumer fraud is concerned, Your Honor, the terms of the statute make no distinction whatsoever. There is no case law to support their position.
And if I could just ask
Sure.
One question. Let's assume, I just want to give a brief hypothetical, but let's say there's no money from the federal government. Mr. Wild just has, his grandmother is a billionaire and is just willing to finance the cleanup of this property. Why would that be? Is that relevant to your client? If your client knows that the property needs remediation?
Yes. The answer quickly, Your Honor, is that it's extremely relevant, and it's the only reason we know of from the record that we have as to why Mr. And it was alleged, of course, why Lamad sold for that cheap a price to this individual. Now, the city had appraised the property and could have had its condemnation powers.
But he doesn't dispute that it needs remediation and somebody's going to have to pay. So if Mr. Wild's grandmother is just willing to finance it, does that determines the amount he's going to ask for the property?
It wouldn't if Mr. Wild hadn't said anything about his grandmother. If Mr. Wild, on the other hand, said and misrepresented who was going to pay for it, I do think it is relevant. It is fraud.
Thank you. Thank you for your arguments. We will take this matter under advisement and issue a decision in due course.